Walking in our home, it's my best gift ever from the Lord. It's our very first home.
Absolutely. It's
so
crazy.
Excited!
Yes.
Well, Lordy have mercy. Hi there. I'm Professor Blackmore, and I'm coming back to you today to spill the tea on how I think this house will crack this case and to preview further trial activities, or the lack thereof, taking place in the criminal court case entitled State of Texas versus Richard Brandon Coleman, aka the husband of Cora Jakes Coleman, who is the daughter of BishopTDJakes of the Potter's House Church. And if you want to know why, in my expert and professional legal opinion, this case technically should be dismissed, you better stick around. And to do this, I'm going back to this house that I previewed in prior episodes of this podcast series, of which said house was purchased by Cora Jakes and Brandon Coleman in July of 2021. Because in all of the strange oddities and anomalies in this crazy mixed up case, deep down in my spirit, honey child, for some reason, I really believe this case succeeds or fails on the issue of the real estate transaction surrounding this house. And I want you to put a bookmark right here for a moment and let me back up for a moment and go back to my last update in this podcast series detailing the attorney's pretrial activities in this case, at which time I previewed numerous subpoenas issued by the court in May on behalf of the prosecutor, and how the court record was utterly and completely void of any pretrial activities whatsoever, honey child, executed by the attorney for Brandon Coleman. Now, I'm not saying this means anything. It could be that the attorney just does not want to put his business all out here in these streets on this church house internet. That could absolutely be the case. Maybe his strategy is to surprise the prosecution somehow. But from a court and criminal rules of procedure standpoint, I don't know how this could work out. But it is still a very possible and viable strategy. And if that is Brandon Coleman's attorney's strategy, then it appears that he continues to perpetuate that same strategy at this very moment in time, because he has not filed one single pretrial document whatsoever up until this moment in this case. Notwithstanding, however, on August 24th, 2023, the prosecution has recently filed yet another request to have the court issue an additional subpoena to marriage and family licensed professional counselor and therapist Andrea Mosley, of which said subpoena requests that she produce the following records to the court. Quote, all records relating to treatment administered to the patient, all clinic notes, psychotherapy notes and records, mental health evaluations, notes, records, etc. for patient AC, by furnishing true and correct certified copies by September the 22nd, 2023 to the District Attorney's Office. End quote. Now, this will be the fourth or fifth subpoena of like kind and nomenclature issued by the court on behalf of the prosecutor. And while it appears that they are busy preparing to put on an open and shut prosecution of this case, it tells me that they do not have any direct evidence and that they're going to try to prove this case through circumstantial evidence of other people, i.e. doctors, counselors, nurses, saying what the child told them. So once again, let me go back up to the grand jury indictment issued in this case, which provides the only criminal charges on file at this moment in time against Brandon Coleman. And although count 1 makes reference to a span of time between June 10th, 2021 and August 11th, 2021, quote, a period that was 30 or more days in duration, end quote, this same count admits that the full indictment relates to only, quote, 2 or more acts of sexual abuse against AC. And we all know who AC is, the adoptive daughter of Cora, Jakes, and Brandon Coleman, end quote. And as I will show you later on, those acts did not span a time period of 30 or more days in duration. And I'll get back to this in just a moment. But the subsequent counts of the indictment make it clear that the prosecution is only really making allegations of events that took place on 2 dates, specifically July 28th, 2021 and August 11th, 2021. And that is because it seems to me that the Ellis County prosecutor can only charge, indict, or convict on allegations that took place in Ellis County. And that is why I am so intrigued by this house. And that is because, to my knowledge, Cora Jakes Coleman and Brandon Coleman had no place of residence whatsoever prior to July 22nd, 2021 in Ellis County, Texas. And for that very reason, would not have been found in Ellis County with either one of their children prior to July 22nd, 2021. So I don't see how an Ellis County grand jury would have any purview over anything that happened from June 10th to July the 21st that may have taken place in Tarrant County on the Jakes compound, which is in Tarrant County, which is outside of the jurisdiction of Ellis County, Texas. And let's be clear, we have no idea what's going on in the background in Tarrant County, Texas as we speak, but that has nothing whatsoever to do with this case in Ellis County. And so, if I were Brandon Coleman's attorney from day one of this case until this very moment, I would be screaming from the mountaintops, honey child, about count 1 of this indictment, strongly objecting to have this count thrown out, and I would vigorously object to the prosecutor putting on any evidence about anything having to do with the time period between June 10th and July 21st, because it is outside of the purview of the jurisdiction of an Ellis County DA or an Ellis County grand jury. And as you will see, once count 1 falls, all of the other counts in the indictment have to fall as well. And why is all of this important? Well, ladies and gentlemen of this church house jury, I'm glad you asked. It is important because the basis of count 1 and every other count in the indictment, for that matter, is alleged based on section 21.02 of the Texas Penal Code, which states, quote, a person, i.e. Brandon Coleman, commits an offense under this section if and only if, number 1, during a period of 30 or more days in duration, the person commits 2 or more acts of sexual abuse, and number 2, at the time of commission of each of the acts of sexual abuse, the actor, i.e. Brandon Coleman, is 17 years of age or older, and the victim, i.e. Cora Jakes and Brandon Coleman's adopted daughter, AC, is a child younger than 14 years of age, end quote. And so, ladies and gentlemen, these are the elements of the crime as alleged currently in the indictment on file with the court. This is an and statute, which means you must satisfy each and every element of the crime by proving beyond a reasonable doubt each element. And so, when the time comes, the prosecution will have to provide proof through direct or circumstantial evidence of Section 22.021 for aggravated sexual assault in this particular case. But because this is an and statute requiring that each and every element be satisfied, when I say and statute, there are some statutes that say that you can have element 1 or element 2 or element 3. Well, that's not the case here. When you read this statute, it means that you must satisfy every single element in order to find the defendant guilty beyond a reasonable doubt. And so again, because this is an and statute requiring that each and every element be satisfied, in my opinion, you don't even get to subsection C of this statute because you can't even establish subsection B1 of the statute. And so it is beyond me that a man is sitting in jail for over a year and somebody does not even urge a motion to throw out the whole thing on this alone. And it leaves me wondering if the prosecution or the defense attorney, for that matter, are even aware of these facts and the crucial nature, in my opinion, that they bear on this case. And so, let me vigorously state this again. The Ellis County prosecutor, just in my opinion, cannot have jurisdiction over anything having to do with this matter prior to July 22nd, 2021, because this is the date, as you can see here on this warranty deed, when the original owner of this brand new real estate property, i.e. D.R. Horton, Texas Limited, signed a general warranty deed deeding the property over to both Cora Jakes Coleman and her husband, Brandon Coleman. And as you can see here in this Instagram post, they are at D.R. Horton on the day that they closed on the property when they signed this deed of trust, securing the mortgage on the property in the amount of $398,000. And so, this real estate property did not even exist prior to this date because prior to the time that the land was developed, all of this property out here in Ellis County was wilderness. And Cora Jakes and Brandon Coleman did not even reside in Ellis County prior to that time. Again, even if they could have moved into this property on July 22nd, 2021, you still don't get 30 days. But as you can see in this photo posted on the date of closing, this house was not even ready for anybody to move into it on July the 22nd. But again, even if they did, it still would not meet the strict requirements of the statute, which requires a duration of 30 or more days. And so, since this is when this real estate transaction was executed, I just want to mark this date, July 22nd, on my timeline, and I want to go back to the indictment. And so, as you can see, there are only 2 dates that are the subject of the criminal allegations made therein, i.e. July 28, 2021 and August 11, 2021. And so when you look at this, we're dealing with a time period of 15 days, not 30 days. Even if you count from the first possible day that they could have moved to Ellis County to reside in the home, which was July 22nd, 2021, you still do not get a duration of, quote, 30 or more days in duration. You get a duration of 21 days, not 30 days. Now, apparently, Cora and Brandon have had some kind of custody of this child since she was somewhere around 4 or 5 years old. And so, the question that remains top of mind for me, that is, if you could meet the 30-day requirement, is why would this man wait 10 years to touch this child for the first time? Now, one could argue that this is the first time in 10 years that he had the opportunity of being outside of the watchful eyes of Bishop and TDJakes. But again, for anyone attempting to make this argument, they would have to allege in the indictment and prove that Brandon Coleman's first sexual contact with the child was on or about July 13th, 2021. And even if it was alleged in the indictment, the question is, how do you prove it? The only direct evidence in a case like this that I can see is direct testimony of the child. And the Sixth Amendment to the U.S. Constitution and the Confrontation Clause states that Brandon Coleman has a constitutional right to confront and cross-examine the witnesses against him. And so clearly all of these record subpoenas to all of these licensed therapists, social workers, and nurses tell me that the prosecution is going to try to find a way to establish that it would be too psychologically traumatizing for the child to testify in person and be cross-examined by the defense, requesting that the prosecution be allowed to prove this case based on the word of what the child said to others about what Brandon Coleman allegedly did. Like, for instance, these records produced from the prosecutor's subpoena to the Cook Children's Hospital in Dallas are pertinent to medical records related to, quote, sane exam and medical treatment, end quote, that took place on October the 6th, 2021. And for those of you who are asking what is a sane exam is defined as an exam of a child who has endured sexual abuse, at which time a registered nurse, specifically referred to as a pediatric sexual assault nurse examiner, SANE, guides the child through a safe and virtually painless examination that documents the physical, emotional, and behavioral results of child sexual abuse and collects any evidence. And so, I can clearly see that this is a litigation strategy that the prosecutor is very likely purporting to execute in this matter, because the only direct evidence in this touching case would be the direct testimony of the child. And that is because the allegations in the indictment do not involve any DNA evidence. This is a case virtually based on the truthfulness and the veracity of the child. But let me strongly state once again, I personally do not see how you even get to this part of the allegations as alleged in the indictment, because it fails on the required duration of time of 30 days or more, because I strongly believe that you need allegations in the indictment of contact on or before July 13th, 2021, and you just do not have this in this indictment. So, what do you think? Do you think Brandon Coleman waited over 10 years to touch this child for the first time during a 15-day period of time when they first moved to Ellis County, Texas? And if so, do you think the prosecutor is trying to build a case to establish that having the child to testify would be too emotionally traumatizing in order to avoid having to comply with Brandon Coleman's Sixth Amendment right to cross-examine the child? And if so, do you think the court should allow this? And do you think this attorney the court appointed to represent Brandon Coleman will ever raise the 30-day issue with the court that, in my opinion, renders this indictment defective? Please let me know by leaving your comments in the comments section below. And I hope you'll also give me a big thumbs up. And I hope you'll also consider donating to this video and my entire channel ministry by donating to the ProfessorBlackmore.com Cash App. And I want to also ask that you please subscribe to my YouTube channel and click the bell so you'll be notified whenever I come back with more Potter's House Pedo-Files updates. And please Also, follow me on TikTok and Instagram.